In today's video, I'm going to explain how much employment cases are worth, and we're starting right now. Hello, welcome to my channel. My name is Brandon Ortiz. I am an employment lawyer based in Southern California. I'm the owner of Ortiz Law Office. Before we begin, let me just remind you that today's video is not legal advice. If you need help with your specific question, you should contact an employment lawyer. If you're in Southern California or California, you can reach me at 888-376-7849. 888-37-ORTIZ, O-R-T-I-Z. Now, the most common question I get as an employment attorney is, how much is my case worth? And there's a lot of factors that go into it. Some of them are legal factors, and then some of them are kind of fuzzy emotional factors that influence jurors. So today I'm going to walk you through how I, as a lawyer, look at and evaluate a case and come up with what I think is a fair value for the case. And you're going to see that there's a lot of factors that go into it. It's going to be a little bit of a nerdy, geeky conversation today. We're going to get a little bit in the weeds. So get ready. So from a high level, 10,000 feet in the sky view, you could come up with a mathematical equation. This is something I follow. It's not anything set in stone, but I think it's a good analytical way of looking at a case from sort of a mathematical perspective. In every case, there are two big components. There's liability, and then there are damages. And there's one does influence the other, but they are separate and unique. And liability, what that means is, in criminal law terms, they would talk about it as guilt or innocence. Did the employer do what we are accusing the employer of doing? Now, in civil law, which is what an employment lawsuit is, it falls under civil law. We don't use guilt or innocence as a term. The term is liability or not liable, but it's roughly the same thing. So, in order to be able to recover damages, you have to prove that there's liability. So if you don't prove that the termination violated the law, then it doesn't matter what your damages are because you lose. You don't get anything. So that's a big consideration in employment cases, because in every case, just about the employer contests liability. They very, very rarely will they concede liability. And then the next factor is damages. And what we're really looking at is, what's the most likely range of damages? And so we sort of take the outliers, the extreme outliers out. We don't look at, the runaway jury verdict, because those are actually not as common. People read the headlines and they see, this person got X million dollars, this person got $1 million, and they think that's all employment law cases are like that. All personal injury cases are like that, and lawsuits are just a lottery ticket. And let me tell you, that's not true. It's not true at all. There are many, many, many more cases where the case gets dismissed or it leads to a smaller verdict that never gets reported. And the reason it doesn't get reported is because it's not news, it's not unique. I mean, the whole entire reason the $1 million verdict is getting reported is because it's so unique and because it's not as common. And so we take out the extreme outliers of, oh, I'm going to get $20 million. We don't really consider that as part of the range of likely outcomes. So if you wanted to look at it algebraically, you would be looking at the range of potential verdicts multiplied times your percentage odds of winning. And I'm going to go through that in a little bit more detail. Okay, so let's dive into liability. You might be asking yourself, well, Brandon, why do you even come up with the percentage of probability of winning at trial? And the reason you do that for settlement purposes is because you don't know what's going to happen at trial. And I can tell you that even the very strongest cases always have a chance of losing. And the reason for that is that juries are human beings. Judges are human beings. They make mistakes sometimes. And mistakes by the jury or the judge, that is an inherent part of litigation. You can never eliminate that risk. It is always there. There's always a risk that a key witness could pass away and is not able to testify at trial. A key witness could change their story in ways that are bad for you. That does happen. And a witness who was, we thought was going to be hostile to us because they're still working for the employer, because they have all these reasons to come in and lie, they might come in and tell the truth. And the case gets a boost because of that. So there's so many factors that could make a case go up or down that, the probability of winning analysis, it's a little bit fluid. And so what I'm looking at is, what are the things that we have to prove. I'll put down below in the description a link to a verdict form so you can see, at least in California, what a jury is going to be going through, the questions they have to answer in the lawsuit. And what I'm looking at is, can the evidence that we have on hand right now, what is our probability of proving each one of the elements that we have to prove in the case? Now, some of these are really easy things to prove. The first question most of the time on these verdict forms is, did the employer, so we'll just, for our example, we'll use Acme. Did Acme Company employ John Doe? Well, that's an easy question. Only in cases where the person's maybe an independent contractor will they dispute that. But in your normal case where they're getting a W-2 paycheck every week or every other week, and taxes are getting paid out, and they've got an employee handbook, the employers normally don't challenge that element. So some of the elements are very easy, and I can say, with a high degree of certainty that you're going to get a yes on that. The other questions, though, for example, was the employee's race, or was the employee's protected conduct, was that a substantial motivating reason for the termination? Those questions are always harder. So the reason we look at the evidence that we have on hand right now, which would include the client's testimony and the client's documents and any documents we've obtained in discovery from the employer, the reason that we're looking at what we have on hand right now is because I've been doing this long enough that I've learned that you really shouldn't speculate about what people are going to say when you question them. You really don't know until you take a deposition and you question them and you find out. And for those of you who don't know, a deposition is something that occurs before trial. It's a process where the attorney gets to ask a witness questions under oath. And there's a court reporter present. There's almost always a videographer nowadays videotaping, or video recording, I should say, the deposition. And so you're able to kind of get a preview of what their testimony is going to be like at trial. You get to ask them questions just like you would in a courtroom. The rules of evidence, same rules of evidence apply at a deposition than at trial. And so you get to find out what their story is and how they're going to answer the questions. And you get to assess, is this person a good witness? Is this person a bad witness? Is this person's story credible? Is it plausible? Is it not credible? Does it contradict emails that we have? Does it contradict documents that we already have? Big part of analyzing the liability aspect is looking at, what story is the jury most likely to believe? And so we're looking at, are there corroborating witnesses? That's probably the single most powerful thing. That and, documents written by the employer. Those two items of evidence are probably the most powerful pieces of evidence you're going to have. I always assume that my client is going to be the person that the jury is least likely to believe. And I assume that even if I have a client who's an outstanding witness, who is charismatic, likable, I assume that even when I have a great witness as a client. Because the fact of the matter is that the employee is the one who has their hand out, so to speak, and is asking for money. And I don't like to look at it that way. I actually look at it as we're collecting on a debt. This is not a windfall, but still, the jury does tend to look at it that way. And so they're going to take whatever my client says with a grain of salt. So when I'm able to prove up my client's case using the employer's own documents, the employer's own emails, the employer's own witnesses, managers who still work there, people who are involved in the decision. When I'm able to get deposition testimony admitting key parts of the case, that evidence always is a little bit more powerful. Because, normally when people lie, they lie in a way that helps them, right? Normally you don't lie in a way that hurts you because that doesn't make sense. Although I think we know people who do that, but most people, if you're saying something that harms you, you're probably telling the truth, or at least mostly telling the truth, because we don't like to admit things that, that's not the sort of thing you would make up, because why would you make it up? It's bad for you. So when you're able to use the employer's own witnesses or the employer's own documents, that does make for a stronger case. Likewise, when you have independent people who don't have a dog in the fight, people who are not best friends with your client, people who are not family with your client, when they just don't have a dog in the fight and they come in and they say, yes, I saw that happen, the employer did say that, or I saw, the boss staring at the employee, grabbing her, whatever. When you have that kind of testimony, that's also very powerful. Now you might be asking, well, Brandon, how do you come up with these percentages? And to be honest with you, it's not a science. It's a little bit of a guesstimate. I base it off my own experience in the trials that I have worked on. I base it on verdict reports. There are publications that publish the results of jury trials. One of those is the Los Angeles Daily Journal, but there's other publications out there that do that. I base it off of talking to other plaintiffs' employment lawyers, and sharing intelligence, learning what their experiences were like. And I spend a lot of time doing that. I think that's a very important job, very important role, I should say, of being a good lawyer, is you have to pay attention to other people's cases and see what kind of results that they're getting. One of the comparisons I always like to make is that it's a little bit like buying a house. If you're buying a house, you can look at comparable houses on the market. You can go online, you can do that. You can look at houses in the same neighborhood, houses that also have a pool like yours, same features like yours, as many bedrooms as yours. Now, it's not perfect because not every result gets published, and it can take a little digging and a little work to find out. It's not like with real estate or houses where it all gets published on websites like Realtor and Redfin and whatnot. So it's a little bit more work, but it is possible. So the first big thing we look at is liability. The next thing we look at is damages. What is the most likely range of damages? Taking out the outliers on the low end and the high end. And so we have to look at the individual categories of damages. Employee, in a typical wrongful termination case, can recover emotional distress damages, economic damages. In most cases nowadays, you can recover attorney's fees. and then last, punitive damages. I'm going to start with punitive damages because that's the least likely category of damages that you're going to obtain because it's the hardest to obtain. You have to prove by clear and convincing evidence that a managing agent of the employer engaged in malice, oppression, and fraud. A managing agent is basically somebody who can make policy for the company on either a formalized basis or an informal basis, kind of an ad hoc, as needed basis. And, in some cases, even though the employer did something really evil or heinous or awful, the employee might be too low on the totem pole, so to speak, in order to get punitive damages for that. For example, if it's a grocery store and it's a cashier who sexually harasses another cashier, unless the corporation approves of it or ratifies it, it's very unlikely you're going to get punitive damages against a corporation because it's very unlikely that a cashier is going to be a managing agent. Now, what if it's the grocery store manager? I would submit that that person is almost always going to be a managing agent because you don't have to set policy across the entire corporation. If you're delegated the authority to decide policy for a substantial part of the business, even if that's on an as-needed ad hoc basis, then that's sufficient to make one a managing agent. But the defense never concedes that. And so that's always a fight. And you've got to prove it by clear and convincing evidence. And, some cases lend themselves very easily to a finding of malice, oppression, and fraud. Other cases don't. For example, sometimes disability discrimination cases don't. Because a lot of times the reason that the employee is not accommodated is not because the company is evil or just hates disabled people. A lot of times in my experience, the reason that the employee is not accommodated is because the company just doesn't know what they're doing and they're incompetent. And that's not a defense in a disability discrimination case. You cannot refuse to accommodate somebody because you don't understand the law. I mean, there's no ignorance defense, right? So, you can get really good liability and win on a failure to accommodate claim, but not necessarily get punitive damages because they messed up, they screwed up. They weren't intentionally trying to hurt the employee. Now, you do be clear, you do have disability discrimination cases. They really are just cruel. They really are just greedy, and they don't care that they're firing the person. And so, I just want to be really clear. I'm not trying to minimize disability discrimination cases at all. That's a big part of my practice, actually. But there are certain fact patterns where it's much harder to get punitives than others. Now, economic damages, which we talked about earlier, that's a very big component in assessing the value of the case because that's the one where it's a little bit more black and white. You can look at paychecks of what the employee was getting in the past, compare them to paychecks they're getting now, or if they're not getting any paychecks, then the math is very simple because it's just what they were making minus zero. So that can be a little bit easier to calculate in some cases. In other cases, it can be a little bit difficult where you're seeking future damages and you don't know if the employee might be able to get a better job someday. Technically, the employer has the burden of proving that the employee will someday get a better job, but sometimes juries have a tendency to flip the burden, make the employee prove that. So that's always difficult. Now, at the beginning of the case, or I should say right after the employee is fired, that's typically when they're contacting me, maybe the day of, a week after. That's when it's really hard to assess economic damages because we don't know if the employee is going to be unemployed for a week, 2 weeks, 2 months, 2 years, and there's a big degree of damages. And so that's when I get asked the question, is it worth filing a case? And it's hard to say. I have to be candid with the employee and tell them that, we might need to wait a couple months. Let's see how things play out. Let's see if you find another job, because at this point it's very hard. That's actually one of the reasons why it's bad to sign a severance offer from the employer without giving it any thought or consideration, because the employer knows that this is the point at which your case is worth the least, because we don't know how long your damages are going to be. And so they try to exploit that and try to get you to agree to a severance right after you've been terminated. And again, if you get a 10-week severance, well, if you're only unemployed for a day, and the day after you get terminated, somebody calls you up and offers you a job where you're making twice as much, then hey, 10 weeks severance, pretty good for only being unemployed for a day. But if you're unemployed for 2 years, then 10 weeks as a severance is a joke. And the reality is nobody can predict the future. And so that can be hard at the beginning. The next big category is emotional distress, and that can also be difficult to project, because that's fuzzy. There's no mathematical formula for determining emotional distress. It's really in the eye of the beholder. It depends what type of jury you get. It depends on what county you're in. Folks in Kern County, which is a conservative jurisdiction, they see things differently than somebody in San Francisco. And so, you can have a fact pattern, where the employee, goes through a depression, has insomnia, has to take antidepressants, has nightmares, maybe even develops a drinking disorder, a binge eating disorder, or gains a lot of weight, loses a lot of weight, who goes through all that. And you can ask 10 people to think, well, how much money do you think would fairly compensate that person for the harm they had to experience? You'll get 10 different answers. And you'll get, one or two that might be, at the low end, that's insultingly too little. You might have one person just say $1 because they don't think you should even be allowed to get money for that. And, you try your best to keep people like that off the jury, but you can't control who's on the jury. And on the other end of the spectrum, of course, somebody could look at that and think it's hundreds of millions of dollars, which, one thing to keep in mind in all this is that judges are not going to uphold that. Because that's another layer in all this, is that after the jury renders its verdict, the judge has the authority to look at it. And if the judge thinks the award's too high, the judge can tell the plaintiff, okay, I'm reducing your award, from 20 million down to 2 million, or even 20 million down to 200,000. And you can either accept that award or you're going to have a new trial on damages. That's called a remittitor. And the defense has the right to ask the judge to consider that. And so you have to survive not only, the jury's review of the case, but also the judge's review, and then appellate review. So there's a lot of hoops you have to jump through. And so those are things that you take into consideration. Finally, with the attorney's fees, that could be another video on its own. But court awarded attorney's fees, there has to be a statute that allows for that, or it has to be called for in an employment contract. Most people don't have employment contracts. I guess if you're LeBron James, you have an employment contract. If you're a big CEO, you might have an employment contract. Or if you're a doctor, actually doctors, it's quite common. They'll have employment contracts. But for most people, we don't have employment contracts. The good thing is that nowadays, most employment law statutes do have statutes that say that if the employee wins, he or she can recover attorney's fees. Now, the court does not look at the contingency fee contract. So if the lawyer is charging you 45% of the verdict, judge doesn't look at that. The judge looks at how many hours the attorney put into the case and what is their reasonable market rate. And the attorney's fees is something you can only And I'm talking about statutory attorney's fees. That's something you can only recover after going all the way through trial. Clients will sometimes ask me, well, can't we get the defendant to pay the attorney's fees as part of the settlement? Well, I suppose you could, but in reality, the defendant is looking at one global number and the defendant doesn't really care how we divide it. So if you made it this far into the video, that means you must like the video. So please hit click, please hit subscribe. I threw a lot of law at you today. And if there's any part of the video or any section of the video that you would like to see me elaborate on more, and maybe I could just do a whole video on that section, please comment below. I love reading your feedback. If you are in need of legal help and you are based in California or you live in California, you can give me a call at 888-376-7849. 888-376-7849.